thinking about, maybe more seriously, and to also tie it back to the entities that we represent, and to see how best we can actually work more efficiently to protect personal data and ultimately to protect the business of the clients that we serve. So in today's presentation, just to give you a brief overview, we are going to look at, in the introduction section, we'll look at what cross-border data transfer means. And we'll also look at the incidence of cross-border data transfer in Uganda. This will really just be sampling a few examples for us to understand how that happens. And then we'll have a brief overview on the global economy in the context of cross-border data transfer. Then we'll proceed to look at the legal framework. Anita has covered it briefly, but that's the Data Protection and Privacy Act, as well as the regulations in as far as they relate to the cross-border transfer of personal data. And we'll also look at the GDPR threshold, what amounts to adequate level of protection in the receiving country. So after that, we'll proceed to look at the risks in cross-border transfers of personal data. And here we'll really highlight some of the common risks and also some practical compliance steps that we can apply in our day-to-day operations. And lastly, we'll wrap up the presentation with key takeaways for the attendees and for us to think about some more as we go about our work moving forward. Okay. So what does cross-border data transfer mean? There is no universal definition for this term. However, for a general understanding, this really simply refers to the transmission of personal data from one jurisdiction to another or across national borders. But we need to know that in the context of cross-border data transfer, mere transit of personal data is not enough. There's a further step of processing in the receiving country that needs to happen. So if you're merely moving data from Uganda and it's going to just sit in another country without any further activity happening or being performed on that data, you wouldn't really say that you've transferred the personal data in the context of cross-border transfer, although yes, you would have actually moved it. So we need to actually appreciate what processing means. In our country here in Uganda, the Act provides for a definition of processing, which is quite broad. It's actually not an exhaustive definition, but it means that processing can occur when any operation has been performed on data by either automated means or any other means. And these activities can include organizing the data, adapting the data, or altering it. But I encourage you to look at the Act and see the exhaustive definition for it. It's a bit wordy, but to appreciate that if you're thinking about transferring personal data from Uganda, take note that if processing is going to happen in the receiving jurisdiction, so your antennas have to actually spring up and you have deeper considerations of that proposed activity. So in Uganda, cross-border data transfers occur across various sectors. To name but a few, I've cited just 4 for our discussion today. We're going to look at banking and financial services, health and research, telecommunications, and employment, just for our better understanding of this aspect. So when you look at the banking and financial services sector, a core activity that banks undertake is cloud-based core banking. So what this simply means is that banks tend to use cloud-based IT infrastructure as opposed to setting up locally set up IT infrastructure, one, to save costs, but also to leverage on the IT expertise of the cloud service providers that actually have a niche in such an area. So some of the key providers of these services are called Temenos and Oracle, and many Ugandan banks use these systems, and they are hosted abroad in the EU or Asia. So in the process of banks subscribing for these services, they obviously have to transfer KYC data on customers to the cloud service providers, as well as transaction information. So that's some of the key personal information that you might actually find that banks are sharing with foreign entities being cloud service providers. So in the health and research sector, we find that donor reporting and clinical trials is a core activity. And here we see that Ugandan hospitals and research institutions tend to participate in international medical studies, and these usually occur through partnerships with renowned bodies like Johns Hopkins and Wellcome Trust. So during the course of these studies, the entities in Uganda will conduct clinical trials, and they have to send through health records, medical test results, patient demographics to the foreign recipients, which can either be academic institutions, pharmaceutical companies, or even international NGOs that have a health-based objective. So there you see that personal data is actually crossing borders from Uganda to these receiving entities outside Uganda. With the telecom sector, a core activity we can take note of is subscriber data management and customer relationship management, known as CRM. And all telcos in Uganda will actually undertake this activity, and they have to rely on technical infrastructure that is most of the time based offshore, especially where you have your telco that's part of a global corporate structure such as MTN. So here we have to note that our call logs, our device information, our registration data that we supply to the MTNs and the Airtels is actually processed by regional processing centers, or it's actually transferred to the parent companies that are based abroad. When it comes to employment, HR management is a crucial activity for any business. And so many companies tend to rely on foreign HR management systems for payroll management, record keeping, tracking, performance, leave, etc., and all the other aspects that affect employment within that entity. So obviously, as a Ugandan company, then you are tasked with having to send employee data or bank details and other personal information relating to your employees to either your parent company, if you are part of a corporate global group, or an HR system vendor that's based abroad. So all these foreign recipients that you see in the last column do undertake processing. They will do some activity on that information that you send. So you have to be aware of that. And going back to what we said, cross-border data transfer actually needs the processing bit to be fulfilled. So the task for all of us is to think back to the activities that we undertake in our different entities, the objectives that we have, and assess how we treat the data that we collect from Ugandans and whether we transfer it abroad. Okay. So looking at the global economy briefly, we have to note that cross-border data flows they've become critical for global trade, digital services, and innovation. This is underpinned by the fact that as of 2023, global data flows contributed more to GDP growth than traditional trade in goods. And on the African continent, we see that cross-border data traffic grew by over 45% in 2023. And this was driven by fintech, cloud storage, and remote work. So with the proliferation of cross-border data flows, then we have to note that new risks will be posed the more that this phenomena continues to grow and evolve. Just to cite two key examples on the global scale, for those of us that might be aware, TikTok and the US are really having serious discussions because TikTok is now undergoing a lot of scrutiny, and this is stemming from national security concerns that America has in regards to the operations of TikTok. This is really because the parent company of TikTok, which is called ByteDance, is based in China. And in 2017, China passed what is called the National Intelligence Law that has very sweeping obligations on any subject of Chinese law to actually cooperate with the government to provide information when it comes to intelligence operations. So the concern there is that ByteDance, of course, then has access to a lot of American user data, and it could be pressured into handing over this data to the Chinese government. The other key example we can take note of the global landscape is that in July 2020, the European Court of Justice invalidated what is called the EU-US Privacy Shield. What this was or is it's a data transfer agreement that was signed between the US and the EU to facilitate the transfer of data, personal data from the EU to the US. So, and under this agreement, the US entities had a self-certification mechanism, so there was not a lot of oversight on how the US entities would actually be monitored centrally. So the concerns, of course, arose from US surveillance programs backed by US laws that were exposing data of EU citizens. So as of 2020, the ECJ invalidated that agreement. So it shows you that with a global landscape, there's always a shift in standards and in the laws, and it can always trickle down to Uganda because we are also part of the global village or market, so to speak. So that's it for the introduction. I'll move on to the legal framework. And really just to reiterate what Anita said, but in greater detail, we just have to be aware that cross-border data transfers are governed by the Data Protection and Privacy Act, as well as the regulations. So some of the key things you have to note in the provisions, that's Section 19 and Regulation 30, is that first and foremost, the Act relates to data processors and data controllers in Uganda who process or store personal data outside Uganda. So that's the reading of Section 19. However, when you contrast it with the regulations, they also include data controllers. So all three entities are covered by this obligation. So we see that they are required to ensure that the country in which the data is processed or stored has adequate protection measures in place that are at least equivalent to the protection that we have under the Act, or in the alternative, that the data subject has consented to their personal data being transferred outside of Uganda. We also see that PDPO has the mandate to publish in the Gazette the list of countries that meet the adequacy threshold. But to the best of my knowledge, this has yet to be done. So what we tend to advise clients in practice is that the most sure requirement that you can meet is obtaining the data subject's consent, but that doesn't oust the duty to actually also, have a vigilance over what the protection measures are in the other countries, as we'll see further along. We also see that in the regulations, further processing or transfer to a third country is prohibited, save for where the data subject has provided express consent. So what this means is that, using an example, if let's say personal data from, let's say, a bank moved from Uganda to a cloud service provider in India, that would be the cross-border transfer that we are discussing. But if that personal data then moved from, let's say, India to Germany, Germany would be the third country of transfer. And so to the extent that there is that further processing envisaged in a third country, the data subject has to be aware and they have to provide express consent. We also see that, of course, there is a penalty in the law for breach of these provisions, and you can be liable to a fine not exceeding 40,000 Uganda shillings for each day that the breach or default continues, or imprisonment not exceeding 3 months, or both. Again, I think PDPO will have to let us know in due course whether they've actually been sanctioning entities in Uganda, or it is still not yet a provision that has been put into practice. But for our purposes, there is actually liability on entities in Uganda that don't comply with this provision. So, and just to dig deeper into the adequacy threshold, having seen that our laws do not define what amounts to adequate protection measures, we then have to rely on the EU's General Data Protection Regulation, that's the GDPR, which provides elements of adequacy. So the GDPR, for our understanding, of course, is not a Ugandan law, but we can actually draw best practices from it because it has actually inspired the way most countries have drafted their privacy laws. So in the GDPR, there are 3 elements. The first being that you need to assess whether in the receiving country there is rule of law, respect for human rights and fundamental freedoms, and relevant legislation on data protection that actually has an effective implementation avenue. So you're thinking that there have to be courts, there have to be regulators in place that enforce data protection laws. Then secondly, you have to assess whether there is existence and effective functioning of one or more independent supervisory authorities. Think an equivalent of PDPO in that receiving country. At least there has to be one body like PDPO or several. And lastly, you have to satisfy yourself that there is existence of international commitments arising from legally binding conventions or instruments on data protection. Of course, the question then would be is how do you actually assess this? The recommendation would be that as a DPO or as a legal officer representing your entity, you could seek the legal opinion of lawyers that are based in the receiving countries that you intend to actually transfer the data to. So you could actually onboard them and you get a proper, well-reasoned opinion on whether that country has adequacy protection measures that are at least the same as what we have in Uganda or even better. So in the absence of PDPO's pronouncement on this matter, as I said earlier, we can use the GDPR as a benchmark for assessing adequate protection measures in the receiving country. Of course, this doesn't also mean that you just really rely on just what you're seeing in the GDPR. Take the extra step to onboard a lawyer in that country to give you a refined opinion on the way forward. Okay. So having seen the legal framework for cross-border data transfers, we are going to look at some of the common risks that are associated with cross-border transfers of personal data. So the first one that's of key importance is the legal and regulatory risk. And with this type of risk, the first really obvious effect is that with non-compliance of the legal provisions we've just seen in our laws, the entity may actually be subject to regulatory sanctions. As we saw, there's a fine for 40,000 Uganda shillings for each day, as well as imprisonment of 3 months, or both penalties can be levied jointly on the entity. We also see that sometimes there is inadequate protection in the receiving country, and this can result in uncertainty over the enforcement regime of the rights of data subjects and even contractual obligations in that receiving country. We also find that in some countries, you might experience an incompatibility of legal regimes. Case in point, China and Russia, which have extreme surveillance laws that allow the state to access data, just as we mentioned with the China law of 2017. So you may find that even though the DPA we have here, our Act, has extraterritorial jurisdiction, the data there will also be subject to the laws because the receiver in the country you're sending it to is also subject to complying with the data laws of that country. So if there's a clash, you're going to have that incompatibility, and the person who will be exposed is the entity as well as the data subject. We also find that where an entity has large operations and data from Uganda goes to many receiving countries, there's increased legal complexity because as a DPO here or a legal officer here, you have to then wade through a web of different legal regimes, trying to assess all the risks at the same time, comparing opinions here and there. So it can actually be a daunting task trying to navigate through all the different regimes and trying to assess what is best for the business. So we also have cyber security risk. This one really is, it could even have been the first one because the minute you're transferring data, even within Uganda, but now across borders, the data is more prone to cyber attacks in the receiving country. And this is especially where that country lacks strong safeguards. If they don't have strong laws that provide for incident reporting, access controls, you'll find that then the data will be compromised to that extent. So, and obviously, if the breach of data occurs outside Uganda, it will compromise the citizens here and expose your entity to investigations and liability. So there's also contractual risk. This is a key risk for us to take note of. And how I can best explain it is in these 3 ways, is that first and foremost, few Ugandan entities can negotiate or effectively customize intra-group data transfer agreements. And this, of course, will result in either inadequate or poorly drafted data agreements that leave gaps in risk allocation and accountability. So you find that most times, if your entity is part of a group, usually the parent has already developed a template for this agreement, and by the time it's passed down to you, it's really just for signing. But beyond entities that are part of corporate groups, we find that even with our vendors here, if let's say you're a bank and you have lots of law firms on your panel, you may find that you either actually don't even have a data sharing agreement, and yet you're always sharing customer data with the law firms that either are helping you with securitization or even advisory work of any nature. So you have to make sure that you have well-drafted agreements with whatever party you're dealing with, especially where there's a data transfer that is envisioned. We also find that there is a risk of poor contractual performance. So where data crosses borders from Uganda, we find that in most instances, the data controller or processor in Uganda doesn't have a strong ability to maintain oversight over the operations or to even enforce compliance in that country. So as a result, the data processors in that receiving country will also not adhere to the contractual terms, and they may even start to subcontract some of their obligations without properly notifying the Ugandan entity. So as a result, then the information is going to change hands. It can end up on the dark web or with some nefarious, people that have negative intentions with regard to that personal data. So contracting is a big, big one that we all have to look out for. Lastly, there's also business continuity risk. This is especially, it can actually arise where the receiving country changes its laws. For example, it could ban certain transfers or even revoke the adequacy standards that were once in place. So if as an entity in Uganda, you've been relying on certain exchanges of information between your vendor or partner in that country, there'll be a sudden disruption because your partner in that country will say, oops, I can no longer actually receive this information, or it won't be as protected, or there is some increased obligation on myself to comply and it's going to cost me money. So the disruptions may be in the sense that costs may increase or actual parishes may have to come to a standstill. And that results, of course, in economic loss and uncertainty in the business. There's reputational risk. Of course, as a business entity, you want to preserve your reputation and just see it grow. So in case there's a breach or mishandling of personal data abroad, this, of course, will erode customer trust. It will attract negative press, and ultimately investors can also withdraw. And lastly, with human rights violations, having seen that the personal data can actually end up either in the wrong hands or in a state where there's too much access by the state to data, this information can be used for profiling, surveillance, or discrimination, especially in the countries that have weak human rights protections. So as a DPO, you also have to assess whether your objective of transferring data aligns with the ethical standards and rights-based principles that your company has, or if it doesn't have, at least you try to now craft something that guides the DPOs as well as any other key decision makers in the entity. Okay, so we've identified some of the key risks. It's not all doom and gloom because there's some practical compliance steps that we can begin to take if we haven't already been taking them to anticipate that risk or even mitigate it. But the best position is to always anticipate and prevent the risk from actually occurring. So these are by no means exhaustive, but really just for us to open our minds to considering the possibilities. So the first step would be is that as a DPO or legal officer, you can conduct a data mapping exercise. You can either use Excel or any other data mapping tool. There's lots of software out there, but the essence is to create a data transfer inventory table or sheet, whatever way you want to call it. And so in your mapping tool, you're going to identify all the categories of personal data that leaves Uganda. So of course, this is dependent on the type of business that the entity you represent does. But if it is, let's say, for example, a bank, what is the personal data that actually leaves Uganda? Is it employee information? if you're just a business entity in Uganda, if you're a health institution, what is the health information that is leaving Uganda? Having identified all the categories of personal data, you then have to map where the data is going, that's the country and entity in the receiving country. The purpose of transfer, is it for analytics? Is it for cloud storage? Is it for payroll? You have to investigate that. And then you also take note of the transfer method. Is the data moving via email? Is it a shared drive? Is it, any other apps that may be developed by a corporate group? You have to also list that. And importantly, also list the legal basis that is informing the data transfer. There are actually, I think, 7 principles, but to name but a few, this transfer of personal data should be based on either consent of the data subject, or that there is adequacy in that country, or that you're performing a contract, or that you're actually complying with a legal requirement to perform that transfer, but there has to be a legal basis. So you just can't wake up out of the blue and just transfer the data on a whim. There's the other also step of performing data impact assessments. So here, before the data is transferred, the DPO can evaluate the legal framework of the recipient country, because mapping is really just sort of spotting where the data is going, purpose, and etc. But here you're breaking down the actual purpose for why you're actually going to transfer the data. And so you're assessing the environment of the destination. So with the legal framework, you ask yourself, obviously, is the protection regime in that country adequate with ours, or even better? You find out whether the surveillance risks or access by foreign authorities and the extent of such surveillance or access. And you also, of course, have to be mindful of the enforceability of those rights, of data subjects' rights in those countries. So the easier way to achieve this, you can develop a checklist or questionnaire, and it can be refined over time, but you can actually start with the crucial questions, and it grows with, of course, practice and experience. So here it is recommended you collaborate with the legal team if you have one, because then the legal team will be able to also engage foreign lawyers to actually advise both thoroughly on the laws that are applicable in the receiving country. You can also update consent frameworks and privacy notices that apply to your entity. Or if they're not there, then you'd certainly need to develop them. But the intention for this step is that in your privacy notices or consent frameworks, you want to insert cross-border clauses that enable disclosure by the entity to the data subject that, one, the data may be transferred internationally. And with that being said, you list the countries involved in this transfer, and you also highlight the risks and the rights of the data subject. And you also provide steps on how they can actually withdraw their consent. And you also ensure that the consent that they are giving to the transfer of their personal data is actually clearly explained and also freely given. So it should be informed consent. Again, here, if you're a DPO without a legal background, you collaborate with a legal team for a better outcome. There's also the option of creating a cross-border data transfer policy. Of course, this will be very crucial because as a DPO, you don't have oversight of all the operations that every department is handling. But then you have to highlight when data can be transferred. Look back to the slide where I talked about the common incidents of transfer. So you would have to sit down and see if I'm a DPO in a bank, what are the common incidents of transfer of personal data? Because the employees need to appreciate those incidents. And then also you designate approval workflows, i.e., is there a threshold of data transfer that needs layers of approval and review and sign off? You highlight those, and then you also indicate the legal bases that are acceptable in as far as your entity is concerned. And you ensure that periodic reviews of data transfers are carried out, as well as reviews of vendor locations. And this is really to monitor that is the regime changing where our vendors or business partners are located, and are those changes actually affecting our operations or not? There's also training staff and management. As a DPO, you take it upon yourself to conduct regular training. Of course, it can first be customized for the key teams like HR, IT, finance, and legal, as well as the executives who are the key decision makers when it comes to selecting vendors, the tools or software that the entity uses, or even partnerships with entities abroad. And in these trainings, to the best of your ability, you can include case studies of local or global data breaches that have a cross-border element, such that your people appreciate the do's and don'ts. And it's also encouraged that you stay engaged with the PDPO and updated just as an individual. So the first key step is notify PDPO as required under the law. There are very many notification obligations in there, so you make sure that you are on top of your game and you file those notices or you write to PDPO if you're required under the law. And when you're unclear about adequacy or risk, it's recommended that you ask for guidance or approval or some sort of opinion from PDPO on how to proceed. You also look out for PDPO's updates, circulars, or even just guidance that they may issue from time to time on foreign data transfers and just data protection in general. And it's also good to recommend to the DPOs that maintaining a regulatory compliance tracker is very important, because with that tracker, you're able to keep your filing history, your communications with PDPO, and even the status of whatever transfer activity you undertook, all in one place. So it is easy for just even continuity. If you leave the role and your predecessor has to fill your shoes, they have a point of reference. Or if there is any sort of investigation or audit check, you actually have good information that you can present to the regulator. So there's also the step of strengthening technical safeguards within your entity. This, of course, calls for collaborating with the IT teams, but it's really to ensure that data is encrypted in transit and at rest, and that the data that's leaving Uganda is access controlled. So you wouldn't want to send it exposed without any restrictions embedded in it. You can also anonymize or pseudonymize that data, whereby you limit or erase the linkage to the actual data subject in Uganda. So you could sort of relabel the information, give it other keys or characters that do not tie back to the specific individual in Uganda. And if your information is going to a high-risk jurisdiction, you ensure that there is additional security controls such as multi-factor authentication and IP whitelisting, whereby you only designate a specific set of IP addresses that can access that data. So again, you work with IT to embed these controls. And last but not least is you have to implement data transfer agreements. It's really important because it underpins the right you'll be able to enforce and even the obligations that you would have to undertake if you're dealing with a foreign business partner or even with just a parent company. So in your agreement, you will have standard key terms like the purpose and scope of transfer, technical and organizational safeguards that you're going to abide by, a dispute resolution clause, breach notification procedures, and also a recommendation is to include customized EU standard contractual clauses, which we are going to see in the next slide. So, but before I move on to the next slide, just to stress the importance of the agreements, it's not only for entities that are part of a corporate group, even as a standalone entity, you want to at least have your templates, your internal templates that you can roll out with potential partners, even within Uganda, but also more importantly, abroad, because you don't want a scenario where a business partner, let's say based in America, comes with a very complex agreement. You have no idea where to start, even with reviewing. So when you get into the practice of developing and polishing up your templates from time to time, you grow the expertise and the skill of spotting certain issues that may actually clash with our laws. So looking at the EU standard contractual clauses, or the SCCs. So these are standardized and pre-approved model data protection clauses that apply to controllers and processors in the EU. And they are really developed to help them comply with their obligations under the EU data protection law. So these SCCs have been around for some time and they've gone through stages of evolution. But what we currently have that is current is the SCCs that were adopted in 2021 on 4th June. So the EU has gone through stages of actually refining these clauses. And what we have now is just a set of 2 standard SCCs. The first set governs the relationship between controllers and processors. And then the second one, which is of more relevance to our discussion, is the SCCs that govern the transfer of personal data to countries outside of the European Economic Area. So these SCCs are not actually a form of law in Uganda, but they can be used as a benchmark or at least a contractual safeguard if you're trying to draft a data transfer agreement. As we all know, the EU has been that model law that many countries have actually drawn inspiration to draft or implement their data protection laws and standards. So there's a very long document that, of course, I could not replicate here. It's called the Joint Guide to the ASEAN Model Contractual Clauses and the EU Clauses. The recent version of 2024 is available at that link. It really has a step-by-step guide of every single clause that you would want to have in your agreement and some considerations you can have. So I would highly recommend that we all get knowledgeable about it, because even if you're not actually going to transport it, but you can actually draw inspiration on some of the areas you may have a blind spot on when you're reviewing or drafting data transfer agreements. So coming to the end of the discussion, we're going to look at some of the key takeaways that I think our attendees have to go away with. So we need to appreciate, first and foremost, that cross-border data transfers are inevitable in today's globalized economy. So you can't shy away from that aspect, and understanding cross-border data flows helps DPOs to anticipate and mitigate risk that is associated with these foreign countries where data flows from Uganda. We also, of course, have to remember that the transfers of personal data has to comply with our data protection laws. And you note the adequacy or consent requirements. With the adequacy, as we've said, our PDPO hasn't yet pronounced itself on the gazetted countries. But for proactiveness, you can borrow the threshold from the GDPR to get an understanding of what you'd look out for in case you are going to transfer the data to that country. And also, of course, you get consent from the data subject. And so you also have to assess the partners that you work with and really probe and find out whether the safeguards they have in their jurisdictions provide adequate protection that is matched with ours. And as I've just mentioned, the SCCs, while not Ugandan law, you can use them as a benchmark to really see what is the best practice when it comes to drafting these data transfer agreements and even the issues you can look out for and negotiate on. And I would stress that, of course, you need to customize them to what is workable for our jurisdiction. And it's not a binding law, it's really just to guide us on best practice. Beyond the SCCs, it's recommended that DPOs become familiar with binding corporate rules and other mechanisms that global companies use to comply with international data protection laws. This is more so for entities in Uganda that are part of a corporate group. You want to make sure that you've had a look at the rules that apply to data. Is there any sort of clash between those rules and our laws? And it's something you can actually flag, because just because you're part of a corporate group, even though there may not be much leeway to adjust that policy completely, it's worth highlighting to the parent that when it comes to Uganda, certain adjustments may have to be made with the way Ugandan data is actually handled. And last but not leastly, transparency and documentation is very, very key. So as a DPO, you have to keep records of all your data flows and even the safeguards that you have in place. And of course, this requires collaboration with many other teams that you may work with, because you may find that you don't have oversight of a certain department that actually affects transfers on a day-to-day. And it's seen as normal business, and there's no appreciation of the risk that can actually occur. And record keeping ultimately helps you to be ready to demonstrate compliance in the event of an audit or a regulatory check or inspection. So in summary, even though we've talked about cross-border data transfers, I think even starting with just what is at home, you can still think about even the vendors you have here locally, that just start with that assessment that do you actually share data with even third party, they could be service providers, people who supply you with certain software, even locally. You just take the extra step of probing and then starting to document all these activities. With that being said, the presentation has come to an end. I thank you all for listening to me, and I can take a few questions in case there are any. Thank you.
Hey, thank you so much, Priska, for that very educative presentation. I believe we have all been able to gain knowledge on the compliance steps, especially that we can take to mitigate the risks in cross-border transfers of personal data. Moving on to the Q&A session. If you have any questions, please type them in the Q&A panel, and please let's ask questions that are related to this training. For questions that are not related to this training, please reach out to us on our known emails. So there's a question in the Q&A. Someone says they would like to hear your comments on the role of the African Union Data Policy Framework on cross-border data transfer for countries that subscribe to it. And then another question, he goes ahead to say, we have companies that are service providers for most systems in Uganda, but servers are placed in the country of the service provider. And sometimes even beyond the contract period, this company keeps the data and access rights for the data back this end. I hope that's clear. So the question is, how do you advise Ugandan companies to protect their data in such a case?
Okay, thank you. On the first question of the AU policy framework, I would want to first highlight that a policy framework would not be a legally binding instrument. Policy frameworks tend to be prescriptive in nature. So to the extent that, let's say, an African nation is subscribed to the AU, it is really to guide that country on how to benchmark the standards. Unfortunately, it hasn't been of prominence because the world tends to lean to the EU data protection mechanism, because it has really taken center stage in informing how the data protection laws have been drafted in many nations. So I didn't address the AU policy in this particular presentation because of the prominence of the EU. But with that being said, what can be taken away from the AU is just the prescriptive nature of policy frameworks. It's really not like something that is binding that you would have to sort of take in that mandatory sense. But as a DPO or as a legal person, you just keep abreast with what it says. But what I can also say generally about it is that you'll see a lot of similarities still with the EU regime. And so that's why the EU regime takes prominence. So on the second question, Anita, if I got you correctly, the person asking the question wants to know what a Ugandan entity can do in a scenario where the foreign service provider has kept information beyond the contracted period. Is that correct?
Yes.
So I think this boils down to, first of all, the process you go through when you're onboarding some of these service providers or business partners. Like I said in one of the slides, most of our entities here don't have a lot of negotiating power, maybe because sometimes we feel like because we are in need of that service, we may not have the ground or the confidence to actually request for some of their agreements or to review some of their internal policy, documentation that relates to data storage. But I think with the more that your entity grows in terms of capacity and even skills, it's part of business negotiation or even legal discussions that we are going to enter into a business relationship. Could you please let us know what you rely on? What is your data retention policy? Can we have a look at it? And you negotiate some of those aspects, and you actually then condense them into your agreement that you're going to sign. But if that then has already happened and you're in a scenario where the contractual period has ended and you believe that this foreign entity still has the data, practical steps would be to contact them and inform them that because of the end of our contracted period, please destroy this data. Obviously, in a practical sense, you may not be able to fly there and really prove that they have actually destroyed the data. However, if you have a certain basis that you actually wrote, and maybe they even wrote back and told you that they had actually destroyed, even if they hadn't, the protection you have here is that should any regulator like PDPO or even a data subject come to complain or sue, you actually took the diligent step of writing formally to ensure that this service provider has actually destroyed the data and given you some form of certification. So it can, I think, give you some sort of protection. But going forward, it's really to have more stronger discussions with the business partners that we onboard. Thank you.
Yeah, thank you so much, Priska, for that. I do not see any more questions in the Q&A. However, there is a question that we sort of argued about yesterday that I would like for you to talk about really. Yesterday we had a situation where we were wondering if I traveled, for example, with my laptop to Kenya, but then I just traveled, but then the laptop contains personal information. And then I just traveled and came back. Does that amount to me transferring data outside Uganda? Maybe you can handle that,
Yeah.
and then I'll take some of the few questions I see in the chat.
Okay. My personal opinion is that that wouldn't amount to a cross-border transfer in the context of the discussion we're having. Why I'm saying that is that the information is on your laptop, right? You have traveled to Kenya. You have not transferred the data on your laptop. Let's say it is work files. You've not given them to any other person. So who is the recipient? I would also ask that question, that who has actually received the information, and if there is such a person, have they processed that information? However, the caveat is that, and of course, this is even a huge debate in the privacy world, that when you go with your laptop and then you access, let's say, cloud services, you see how you can access your Google Drive documents wherever you are. Is that transfer? Who is at fault? Now, that is the gray area. But in as far as you actually taking a step to move files from your laptop to another entity, my opinion is that that wouldn't be a cross-border transfer. Because then, Anita, the question would be, who received it and did they process it or take some other further step on that data? So my question would be no. But it's one of those things that, yeah, you could argue it either way, but looking at the information we've looked at, I would say squarely it doesn't fall on all fours.
Yeah. Okay, thank you so much, Priska, for that. Now, there was a question around, okay, someone was asking if the data breach incident has happened from the destination location. Who becomes liable in this case?
So that's a good question, because I would go back to, first and foremost, two things that we keep in mind. One is the extraterritorial jurisdiction or application of our Data Protection Act, but also two, how was risk and responsibility of risk allocated in your agreement? But my answer would be that if the breach has occurred outside of Uganda and it's your business partner or whatever vendor, let's say in the US, who has experienced that breach, they would be primarily responsible, in the sense that supposing you have an agreement. So the agreement would say that they have a duty to notify you as soon as, maybe even within 24 hours or even less, of the breach, such that you also notify PDPO. I've, I think, encountered maybe 2-3 clients that had such an incident where there's a breach, let's say in Japan or wherever, and there's actually Ugandan personal data that has been affected by the breach. So what happened in this case, the entity actually reached out to us for advice, and we advised them that they have to notify the PDPO of that breach. And what happens in the practical sense is that once you notify the PDPO, then of course there's some added inquiry. There's that form that you fill in. You sort of give details of how the breach happened. Did you have any safeguards in place? Have you taken any measures to mitigate further damage, or steps to manage the risk? And even beyond that, PDPO can actually also guide you to either actually now reach out to the data subject themselves to inform them. So in a nutshell, that's really the answer. It's there's a contractual perspective, but also the fact that our DPO Act, has something to say about it. But primarily, it's the entity in that country that would have the primary obligation to manage the risk and inform you, and then you also take steps to cover yourself.
Right. Thank you so much, Priska. I think we are going to have to end the Q&A session here. I have shared a link in the chat for the participants. Kindly click on that link and give us feedback on today's webinar. The feedback you give us helps us to make future webinars better. I see
Maybe,
someone
Anita,
sharing another question. Priska, would you like to take it maybe before we close?
I have another engagement, but there's something I've seen. I think Vanessa is
Mm.
asking, no, not Vanessa, someone has asked for the SEC's document. You'll see in the slides, this is Merab who has asked, the slides have a link to that document, the very updated version of it. So you'll be able to click on the link and access that SEC's document. Okay, Anita, one more question. I hope it's not a loaded one.
Yeah, someone says, supposing we are implementing a cross-border project with other partners and we are supposed to share with the lead partner who is outside Uganda, does this tantamount to data transfer?
Sorry, I didn't get the first part of the question.
Supposing we are implementing a cross-border project with other partners and we are supposed to share with the lead partner who is outside Uganda, does this tantamount to data transfer?
It would, but the question I would first ask is, are you transferring any personal data in this proposed project? If the answer is yes, the question would then be, is your lead partner going to process that data? And I'm taking us back to what processing means. It's a very, very broad term. Your partner could actually reorganize that data, give it certain indexes, put it in a certain registry, retrieve it, edit it. So if they are going to take any act of processing personal data of Ugandans, I would say that yes, that is a cross-border transfer. In even the classical sense. So then you'd have to actually walk through all the risks and ensure that you're covered and you have a good agreement that governs how you're actually transferring this data and how you're going to allocate risk and manage it. But yes, it would amount to a transfer.
Yeah, thank you. Thank you so much, Priska. We have come to the close of this webinar, and for Priska, I would like to thank you so much for generously sharing your expertise, your time, and your knowledge with us today. Your insights and, of course, the practical guidance you have given is very invaluable, and we are grateful for your contribution to our community of data protection officers. And of course, to the rest of the participants, thank you so much for joining today's webinar. We hope you found the discussion informative and helpful. For those that have been asking for the presentation, it will be shared on your emails that you used to register for this webinar. And of course, the recording will be shared as well. Priska, do you want to give us any closing remarks?
Yeah, just briefly, want to thank you for all attending. It's been a pleasure to actually put this information together for you. In case any of you need to further consult me, please feel free to reach out on LinkedIn or wherever. And I also just want to stress the importance of really just data privacy in the times that we are living in. So your role as a DPO or a legal officer is really quite crucial, because we tend to think of driving business growth, but we shouldn't also do it at the expense of privacy, because I mean, once you lose your privacy as a human being, as an individual, then the core fundamentals of our civilization would be eroded. So we have a key role to play, and I'm really available for further consultation and guidance. Thank you.
All right, thank you so much. Thank you, participants. Please keep the conversation flowing on our social media channels. And thank you once again for attending. Have a wonderful day.